Ms. Solich, you may proceed.
May it please the court. Good morning, Your Honors, Counsel. I am Soich, and I represent the state of Iowa. Your Honors, this case obviously will be a continuation of the argument that the court just heard. And in our case, in the case before you, and in the Brown case, the court is asked in all three to kind of define the parameters of propriety of expert testimony in child sex abuse cases. We have to start in this case, as with any expert testimony case, with Iowa Rule of Evidence 702, which provides, of course, that a qualified expert may, if his or her testimony will assist the jury in understanding a fact in issue or understanding the evidence or determining a fact in issue, then that evidence should come in, if by a qualified expert. So, Your Honors, the threshold question we always ask at the beginning is, does this assist the trier of fact? Then, of course, in child sex abuse cases, we have to start with the Myers case. And we start with the idea that in Myers, the court said experts will be permitted to testify as to relevant mental and psychological symptoms present in sexually abused children, but will not be able to opine directly or indirectly on the credibility of the witness. And that, of course, is the bugaboo in these cases, indirect. Direct, I think we all can agree. Do you believe this child? Is this child truthful? Did you find that this child was credible? That sort of thing, I think, is clearly on the wrong side of the line, and we ask you to continue to find that that is on the wrong side of the line. We are not here today advocating that you allow a witness to testify about the credibility of a child directly. But, Your Honors, of course, what we're here to talk about is this indirect effect. And as Ms. Fiala stated, really any evidence that either side presents is going to result in some bolstering of that side's evidence. In a state's prosecution, once we have the witness telling a certain version of events, the doctor, the treating psychiatrist, whoever, whatever expert we call, is going to, in essence, corroborate and therefore bolster or support indirectly.
But Ms. Soich, we're really talking about a special subset, that is, people who have talked with the victim, spoken with the victim, and are then offering testimony on the victim's demeanor when they were interacting with the and that's the subset here, and that seems to maybe be closer to the line than just the run-of-the-mill witness that is obviously going to be bolster, hopefully, the case that they're called to testify on.
Well, Your Honor, I would say though that in our case especially, we have a treating physician, a therapist, so it's not really just the statements. In fact, Dr. Mary Casey didn't testify as to statements of this particular child. She testified about her demeanor, her constricted affect, but she also testified about these behavioral symptoms, the cutting of the hair, the wearing baggy clothing, and desexualizing or going the other direction sometimes and going the provocative route, but she testified more towards actual symptoms. So we would urge you to find that it's really no different than, as again Ms. Fiala said, the medical expert who says, and we see this every day in child sex abuse cases, I examined this child, there are vaginal injuries, there are anal injuries that are caused by blunt force trauma consistent with penetration of an adult penis. Nobody objects to that.
But those doctors are there to treat that victim of physical injuries, okay? And that's why they're being examined, and if there's bleeding or tearing, there has to be some things done. In your case, you're right. Casey was a physician treater. Bibbins was an investigator again, and right. It was her. She did it for the purpose of investigating. Do you make a distinction between those two witnesses?
Your Honor, I don't. And I think your questions were interesting about the fact that you do make that distinction.
Well, the case law does, not me. We have Hildreth, okay, that makes that distinction, that says treaters are okay, and we have other cases that say treaters aren't okay.
And Hildreth, much of Hildreth concerned the hearsay testimony of the medical diagnosis and treatment exception, though. So that might have been why the focus was on a treating physician rather than a non-treating physician. But I would say that most of the cases, when you look at the cases generally, I don't think they do generally draw the distinction. Maybe we're inherently distrustful or a little more distrustful of sort of investigative witnesses, forensic interviewers, than we are treating physicians.
Well, it seems
But,
the cases nationwide draw that distinction.
Your Honor, I looked at some of the cases nationwide, and I found, and I hate to jump from you to Justice Waterman, but while I'm thinking of it, if I might just answer the consistent with language, I think that I've found several cases where the court says it's okay for an expert to say, I'm not sure if it's the treating physician, Your Honor, or it's a general expert, but where the expert is permitted to say these behavioral symptoms are consistent with a child who's been sexually abused. I think Mississippi, Texas, North Carolina all allow that sort of consistent with language. New Hampshire does not, Massachusetts does not, Oregon I think does, Washington State does if there's been some sort of, if it's been a fact and issue that they need to respond to. So I think that they're all over the map. And
Why do we need all this? I mean, I understand the cases are divided, and the real question to me is one of balance. On the one hand, we want the jury to be reasonably well-informed by experts who talk about, delayed reporting, for example, which some people might find counterintuitive, but all the experts will say is relatively common, and the emotional features and so forth. We surely, on the one hand, we want a jury to be informed that in child sexual abuse cases, the best science is that, you have these features. We surely want that. On the other hand, the kind of general rule has been that we don't want, expert witnesses to come in and say, I believe him, I believe him, I believe him. And I think you, by nodding your head, you surely understand that. So we've got these two competing interests, and we're trying to balance them. If a jury is informed in a general way about the fact that child sexual assault victims are often relatively non-emotional in the presentation, haven't you armed the jury with the facts that it needs? Why do you have to go that extra step other than to enhance the likelihood of conviction?
Your Honor, I think sometimes we go that extra step because that's how the evidence presents itself.
But can't the
And I
jury
think-
figure that out? I mean, the jury can go back and say, well, boy, the expert said that a non-emotional presentation is kind of common. So there's no problem here that the victim here was kind of flat in her testimony. Yeah, the expert says that happens all the time. Yeah, in the jury room. I mean, the jury has what it needs.
Well, they might be able to figure that out, Your Honor, but I guess my point is when we have an expert who is sort of a 2-in-1 expert, why can't we use that expert to testify as to the whole thing? And I know your discussion in the previous case was about, well, isn't it true that all of these cases say you can have somebody testify about the general symptoms and characteristics of sexually abused children, and then maybe you can have somebody else testify this victim, and of course in Gatir, the rape trauma case, that's exactly what we had. This victim happens to have exhibited all these, and let the jury do the connecting up. And frankly, we get calls all the time at the Attorney General's office about how do we stay on the right side of Myers, and I have said for many, many years, to be absolutely safe, you don't connect them up. You put the general stuff on, you put the specific stuff on with a different witness, and then there's going to be not even a question. But, Your Honor, is it fair to say that when we have a witness like Mary Casey, who knows about the science, who is an expert, and who also knows about this particular victim, why can't we let her testify as to both? Why do we say it's okay if it comes from two separate witnesses, but not okay if one witness, and in fact, I would argue to you, Your Honors, that this one witness is probably even a better witness. Why deprive the jury of evidence of this witness who intimately knows this victim from treating her and who knows the symptoms of post-traumatic stress disorder and generalized anxiety disorder?
I guess the problem is, in part, the Casey testimony, and correct me if I'm wrong, of course, but in part the Casey testimony is based on her belief that the statements made by the victim are truthful.
Your Honor, that's where I would disagree with you.
It's indirect, by the way, but obviously not direct.
Yeah, indirect, but I think, again, so indirect as to not really be a comment that the statements are truthful. I mean, we assume that doctors take their patients as they find them and they treat them in the way to help the patients, but she never, I think, even suggested that I believe this child. And we have seen testimony, certainly, where they do that. And I'd like to point the court to the Tracy case, and I suspect Mr. Simmons may talk about Tracy as well. We argued that together 22 years ago. I think he has much fonder memories of that oral argument than I do, probably. But in Tracy, it really does point out, it's distinguishable from our case factually, but it really points out when the line is crossed. Because in Tracy, we had a recanting sex abuse victim, a young girl. We put her on the stand. Then we called a number of witnesses, but one of them was Dr. Hunter Calmly. He testified, here is the syndrome of child sexual abuse accommodation syndrome. He said, it's likely, or this would account for her recantation. Then he continued to say, I believe that she was telling the truth in the first instance when she made the allegations. Clearly, Your Honors, I think that is very easy to see. That's where he crossed the line. Absolutely improper. We would not argue today that that was proper. He also added the kind of Myers statistics where he said, I think his statistic was slightly different, 2 or 3 in 1,000 children.
I agree that both cases we're dealing with today are, as I read our precedents, they don't clearly place these cases, and so we're now refining the line drawing. But as far as your 2-to-1 point, why do we need to bring in 2 witnesses? I mean, couldn't Dr. Casey have testified here, general testimony on people who've been victimized by sexual abuse? Here are some of their characteristics. Then, at another point in the testimony, testimony about specific things that she observed with the victim. But not, I mean, and here it was the prosecutor that went directly in it, not going into this consistent stuff. The question was asked, do you have an opinion based on your line of work, based on your credentials, as to whether the symptoms were consistent with a child dealing with sexual abuse trauma? I mean, you don't really need that piece, do you? You can argue that in closing argument.
I think you could argue it, Your Honor, but I don't think that it makes the testimony inadmissible. I think that, again, the same reason that it makes it perhaps obvious that the jury could connect it up probably makes it not that prejudicial. They did just go that one next step, but they didn't.
In terms of prejudice, this is not like, I mean, Ms. Fiala maybe had a better argument on that one. There it was a volunteered answer.
Right.
Defendant didn't take the stand. Here you really have a swearing contest, right? Defendant took the stand and denied the conduct pretty vigorously.
He did, Your
Honor. So in that case, why does the prosecutor need to go there?
I think that the prosecutor and the witness were trying to stay on the proper side of Myers because they did use the consistent with. I think in their view, and we would urge you to find that it's not as if they said, if the prosecutor had gone to the next question, which may have been, in your view, Dr. Casey, has this child been sexually abused? Or again, we all know is this child telling the truth? Do you believe this child? All of that, clearly improper. But even has this child been sexually abused is a little closer to the line. Consistent with sexual abuse, and Dr. Casey testified on cross-examination, I think the defense lawyer asked her immediately, when you say consistent with, that isn't a definitive statement, isn't that right? Consistent with can mean it can be a reason, it might not be a reason. So again, I think, I'm sorry, Your Honor.
No, I think I follow your point. Because you have a little bit of time left, I want to turn quickly. If you're right, there's an excited utterance issue that bothers me in the case that Mr. Simmons has raised. And this is, as I understand the facts, basically not disputed, about 36 hours after the events, a day and a half after the event, the mom sends the child over to the neighbor, kind of hoping that the neighbor will question the child and they'll get through that, a version of what happened. How, in any way, shape, or form, does that get through as an excited utterance. I'm struggling with that.
Your Honor, are you most concerned about the time? Are you most concerned about the spontaneity?
All.
All of it? Okay. Well, then let me, in my 6 seconds remaining, let me say absolutely cumulative to the testimony that the little girl told her mother that was very clearly an excited utterance, not prompted by any questions, told at the first available opportunity. So that's what I would say to that. If the court has trouble with the excited utterance, it should find that it was cumulative to the other testimony. Thank you, Your Honors.
Thank you as well, Counsel. And Mr. Simmons.
May it please the court. Good morning. I'm going to ask the court to bear with me this morning. I am in no way, shape, or form used to being second batter up. And not only do I not get to go first, I don't get as much time to argue. And the most galling thing is I don't get to be third batter up. So I would like to talk about an issue that has not gotten fair treatment yet. And if you don't want to talk about the issue, that's certainly your prerogative. But please let me state something about the motion to dismiss and the prosecutor's withdrawal of the agreement to dismiss. It deserves a full contractual analysis, and it hasn't gotten it yet. What Santabello tells us is, and this is something that you don't get to do a lot, the standard is fair play. The standard is fair play, and the facts in this case are undisputed. And that makes it a pure question of law, and I think it makes it a pure question of contractual law. Now, what the Court of Appeals said is they did one point of analysis in one paragraph and said, when Mr. Dudley missed the expedited deadline, the deal was off the table. End of story. But it wasn't off the table, and there's two reasons why it wasn't off the table. Why would the prosecutor get to unilaterally expedite the deadline without any warning and giving the defense attorney 7 to 10 days to get it done? And think about this. This is what the prosecutor knew, and this came out of his own mouth in the motion hearing. This is what he knew. He knew Mr. Weiland was struggling with his law partners in his law practice. He was having trouble getting into his office. He was having trouble communicating with clients. He knew that Mr. Dudley was living up in Minnesota free on bond, and he gave him 7 to 10 days after the original agreed deadline was, it's got to be done before you, Mr. Weiland, take the deposition of the complaining witness. Now, as the deal was first made, that time frame was somewhat in Mr. Weiland's control. He was going to know that when he took the deposition of the complaining witness, the deadline expired. Why would the deal be off the table on a unilateral expediting of the deadline? And if the standard is fair play, what was fair about that on the prosecutor's part? I think when you do a contractual analysis, you translate fair play to good faith. Was that a good faith move by the prosecutor? Absolutely not. He knew what the circumstances were. Okay, so then what happens? Did Mr. Dudley show good faith? Of course he did. You know what? It's undisputed that it was somewhere in the middle of June of 2011 that the prosecutor expedited the deadline, and it was undisputed it had to be done in 7 to 10 days. Well, if you look at the report from the polygraphist, the date on it is June 21. Even though they had to go to Stillwater to do it, even though Mr. Dudley had to travel from Faribault to Stillwater to do it, even though they had to line up what looks to be from the exhibits on the motion, the foremost polygraphists in the state of Minnesota. They got it done by June 21. And
Mr. Simmons, as I understand, and I have to admit I didn't focus on this issue maybe as much as I should have, but as I recall, one of the things the prosecutor argued later at the hearing on the motion to dismiss is this wasn't going to be a unilateral polygraph where the defendant gets to go just do it by himself. The idea was they were going to let me know there was going to be a polygraph, so I would then know that that was the only one that had been done and that he had in fact passed it, as opposed to the defendant kind of going off on his own without informing the prosecution that he was going to be doing a polygraph. That was one point I thought that was raised, wasn't it?
well, I think what you're getting there is what the judge ruled, and I don't think those words ever came out of the prosecutor's mouth. Judge Goodhue said, you can't just run off and get a polygraph and then come back and say, aha, I passed it. But what I argued was there were only two conditions when this agreement was made. One condition was that it be a certified polygraphist. That was definitely met. And two was the deadline, which was going to be the deposition of the complaining witness. There's no tell me who you're going to go see and let me check this person out. There's none of that in the agreement. There was only two conditions, and those were it. Now, the prosecutor could have made those conditions if he wanted to, but what you remember reading is what the prosecutor came up with after Mr. Dudley passed the test with the foremost polygraphist in Minnesota. And look carefully at the motion exhibit of the CV of this polygraphist. His first 9 years of his career, he was a police officer. The rest of his career, he worked for the Minnesota Division of Criminal Apprehension, same thing as our DCI. He's worked for the department.
Hold on, I'm sorry to interrupt you.
Go ahead.
I'm struggling with this a little bit, but wouldn't you ordinarily think if there's going to be a polygraph that the parties are going to get together and kind of establish the ground rules for it and maybe have an observer there and it may well be that the polygraphist that ultimately did it had some good credentials, but this is the language, as I understand it, of what you characterize as agreement is fairly loose. Okay, there's going to be a certified polygraph examination of some kind, but is there an implied notion that we're going to kind of agree to the ground rules surrounding it? I think that's what Justice Mansfield may have been getting at, and if not, that's what I'm getting at.
I don't think it's something we can guess at, though. This is contractual law. It's not what.
Yeah, but when we have these contracts, on occasion we get that are Spartan. It's not unusual to have implied terms that go beyond the literal terms of the contract.
Well, I want you to also consider this. And in my 30-some years as a criminal defense attorney, I've had plenty of occasions where a prosecutor wants me to find a way for him to get rid of a case. Go get me a polygraph report, we'll dump it. Go get me a substance abuse evaluation, says he's okay, we'll dump it. So I don't know what went on there, but it's not in the record, and that's why we have to stick to contractual analysis, because those were the only two conditions. And the prosecutor didn't really object to who the polygraphist was, because he could not. This guy is, still doing polygraphs for the Department of Corrections, prosecutors, police departments, the public defender up there. Everybody trusts this guy. His word is gold. So he couldn't complain about that. He did complain, well, I don't know how many you did. I don't know if he got your proper ID. Well, we know he got his proper ID. He's a certified polygraphist who basically is a police officer. Of course he got his identification. But these are things he came up later when he didn't want to accept the result, because now he had himself invested in the case, and he didn't want to dismiss the case.
There was a second polygraph, I gather, right?
I guess. We don't know. The DCI produced no report. The prosecutor says Mr. Dudley went to the DCI, but nobody knows what was done or when. How's that for good faith? Mr. Dudley produces this full report instantly from the foremost polygraphists in the state of Minnesota The DCI doesn't even prepare a report. We don't know if they beat him up or what they did.
One of my reactions as I'm just sitting here listening is that maybe this is a matter for PCR.
Well, maybe it is, but it shouldn't be. It's a contractual analysis. We had a simple contract with two simple conditions. The prosecutor unilaterally changed the terms when he was afraid he was going to lose. He got himself invested in the case. He went to see the victim and meet with her, and now new rules. But even then, he didn't pull the deal on the basis of the deadline. There's nothing in his memo about his objections.
Counsel, that seems like a lot of speculation that could get fleshed out in evidentiary hearings in a PCR.
Well, it could, but it's a contractual analysis. I mean, so what are we going to do? Are we going to try to see if there was a meeting of the minds? Are we going to try to see what was in the prosecutor's head and what was in Mr. Weiland's head, what was in Mr. Dudley's head? I mean, let's do a contractual analysis. We don't do that stuff in contractual analysis. The conditions are undisputed, and the conditions were met by Mr. Dudley, and the state did not perform.
While we have some time left, I think I want to switch gears to the other issue that we talked about, yes, primarily with other counsel. What's wrong in this particular case with allowing a treating physician or psychologist in this case? She is obviously a treating psychologist. She did give a diagnosis, offering her opinion about the complaining witness just like we would in any other type of civil action. Using the example that Justice Wiggins gave earlier, if you go to a doctor, they tell you things based upon your discussion with them, they end up with a conclusion that, yes, this is consistent with a back strain. What is wrong with this witness testifying in this particular case to the physical manifestations and symptoms of her diagnosis?
Well, you finished with a very general description of her testimony there on your question, Your Honor. And one thing I'd like to say about treating physician, well, it's not a physician, it's a treating psychologist in this case. And there's distinctions between somebody who just evaluates and is not treating, just does an evaluation, and then there's the psychologist. In this case, Dr. Casey, I think, had seen the complaining witness for a year or something. There's a point where I think the bond between the psychologist and the patient gets to be too close to give a fair opinion, and it gets into vouching because basically the psychologist is saying, I trust this young woman. I believe her. I just wanted to scream this morning when the arguments about the right to counsel were going on. Again, as 33 years as a criminal defense attorney, the way you build a relationship that is effective with a client is trust. And you only develop trust by having at least one really long conversation and relaxed conversation with your client and getting everything out on the table and getting everything resolved. And that's what Dr. Casey's getting across the jury. I've talked to her 11, 12 times.
Why can't you deal with that on cross-examination?
Well, you can do that on cross-examination. But why can't you also bring in your own expert? And that's the other problem, Your Honor, is now we get to fairness. And the one thing the defense attorneys never did, and I don't fault Mr. Plunkett because he came into this case late and he was arguing the motions in limine late, but let's talk about a 403 analysis. Is it unfairly prejudicial if the state gets to do this but the defendant doesn't? Why couldn't Mr. Dudley go see a psychologist for a year, personality profiling? Did the defendant
have a psychologist, or was there any type of expert testimony that was denied to the defendant in this case?
No. But if we're going to go that route, where a treating psychologist can say, I've treated this young woman for a year, and not only is it PTSD, it is not combat PTSD, it is sexual abuse PTSD. If we're going to allow that kind of thing, is the next step in the next case then, well, I've been evaluated by a psychologist, and the psychologists have these scales, they have these tools available. The psychologist says this man is not a pedophile, This man is not a predator. I've spent a year with him, and I'm certain he would not sexually abuse anyone.
And of course, the state uses precisely that kind of thing in the SVP proceedings.
Correct.
Counsel, if I can just, I need to get in here before your time gets expired.
You've got 19 seconds.
Sometimes it's hard up here. My question is this. So I want to make sure I understand where you draw the line between proper testimony and improper testimony. Is it your position that this crossed the line solely through the use of the testimony about the complaining witness's behavior that was consistent with PTSD suffered by sex abuse patients? Start with that, and then I have a follow-up.
Thank you. If I might, let me just read directly from the Court of Appeals opinion, because I think it answers your question precisely in one way, and I'd like to answer it in another way also. And Judge Vites-Warren wrote this at the end of the first paragraph on page 12 of her opinion. It's one sentence at the end of the paragraph. If the operative distinction between permissible and impermissible testimony is the specificity with which the expert ties the general characteristics of the disorder to the complaining witness, there is no question in our minds that Casey's testimony was impermissible. And I think earlier Justice Apple was like, where's our line? We got to draw the line somewhere. Where is our line? I think that's a line that Judge Vites-Warren very deftly pulled out of all the very confusing case law. But for this particular case, please do not forget about the cumulative prejudice. You know, the next door neighbor. It's this same kind of vouching thing that comes in a so-called excited utterance. Well, I know this young lady very well. She's a good friend of mine, and I interrogated her, and she didn't say it, but obviously what's happening is she's saying, I believe her.
So, counsel, if specificity is the pole star, and I'm gathering you like what Judge Vites-Warren said.
I didn't file the petition here.
So is the specificity line crossed when Dr. Casey says not merely here are the common characteristics shown by sex abuse PTSD victims, but further, I observed those specific aspects of demeanor in this patient. Is that a violation of the rule as you're conceiving it?
Well, yes, I think so. And if I might, there's one other thing I think you should pay attention to.
And why?
And why? Because, and the judge actually did it. It was too late, but he actually did it with the forensic interviewer. Now you're getting to the point where it's getting too close to vouching. And if you have to draw that line somewhere, this is the way to draw it. But let me remind you of one other thing, and this is the struggle that Judge Sackett had between Sivansa and Passengrau, and she resolved it in Passengrau. And Judge Schlegel, and boy do I miss him, Judge Schlegel is the one who announced it first in his dissent in Sivansa. And that is, don't let any of this in unless the defense, and they might be doing it in their cross-examination, they might be doing it in their own case, unless the defense is flat out saying or, just unmistakably implying that a young child who was abused would not be acting this way, don't bring any of that stuff in unless the defense is questioning the way the complaining witness was acting.
Thank you, counsel.
Thank you.
Rebuttal.
May it please the court. Your Honors, I dislike rebuttal about as much as Mr. Simmons covets rebuttal. But I just have two quick points. As to the the polygraph examination and the offer, I want to make it very clear to you, Your Honors, that there was not an offer and an acceptance in this case. There was this offer, and then, as the prosecutor said, about 70 days went by, he never heard a thing about whether there was going to be an attempt to take a polygraph examination. And there was no nefarious reason for the prosecutor to move up the deadline. The prosecutor said, I'm traveling, I need to get working on this case. It's been kind of languishing for 70 days. If I go up to Minnesota to interview this young victim, the deal is off the table. And that he gave him about 7 to 10 days to complete that. And the defense lawyer, I think it's quite clear, Your Honor, said, my client didn't want to take a polygraph for a long time. So the defense lawyer finally enlists the aid of the cousin, Joe Dudley, who's a lawyer up in Minnesota, and sees if he can get him to agree to take a polygraph. That does come eventually, Your Honors, but it comes too late. And it's not as if this off the table for no reason at all. He, again, had a legitimate deadline. He said, if I have to go up and make this little girl talk about this, then the deal is going to be off the table if you haven't taken the polygraph. Quickly, Your Honors, with regard to the argument that could the defense then call an expert, switching gears completely, could the defense call an expert to testify, my client is not a pedophile? I would just point you to the Hulbert case, and I think that's about a 1992 case. Bart Hulbert is the name, and in that case, the defendant wanted to do just that. He wanted Dr. Ralph Underwager to testify. I have examined this defendant. Here are the criteria, or here are the characteristics of pedophiles. This defendant has none of these characteristics, and the court excluded that. I think the case is interesting, Your Honors, in that it does go into a bit of detail about how this is sort of professional character evidence, and the court says it's kind of an unusual posture that it's character evidence, but it's character evidence by a professional, and they go through some other jurisdictions, and then the conclusion in Hulbert is, because of this, the uncertainty of this kind of evidence and its true nature, the court did not abuse its discretion in excluding that evidence. Now, if this court comes to a different conclusion in Myers, or takes Myers and refines it a bit, it may be down the road somewhere, it may open it up a little, but I still think you would have to look at the idea that it's also character evidence by a defendant, which would go to the whole issue the jury's supposed to decide. Did this defendant do this? Versus in our cases, is a child sexually abused is only half of the equation. The other half is, of course, sexually abused by the defendant. But I just have you take a look at Hulbert if you'd like to respond to the issue raised by Mr. Simmons. We ask that you vacate the Court of Appeals and affirm Mr. Dudley's convictions for second-degree sexual abuse. Thank you.
Thank you as well, counsel. The Dudley case is submitted as well as all other cases on the docket this morning, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.